This state law tort. And so now what I want to talk about are common defenses to anticipate. So, before you file suit, you know who you're representing, who the plaintiff is, who you're suing, and your causes of action. But it's very important to think about what defenses you might face. You don't want to waste your time filing a suit and get your client's hopes up if there's some major roadblock in your way. So the Heck bar is what I referenced earlier. This comes from Heck v. Humphrey. I think I included this in the materials. And basically what it means is that if a 1983 judgment would render a criminal conviction invalid, the claim cannot proceed. So therefore, if you have been convicted of a crime, you cannot sue over the validity of that conviction. You cannot collaterally attack it, is the word that the courts use. So for example, if someone calls you and says, I was arrested, they claimed that I beat the officer up or hit him, but I didn't, but I pled to that. I pled to it because I wanted to get out. Can I sue them for that now? No, probably you cannot. There's a lot of variance here. You have to look at what the person was convicted of exactly, and often people do not know. And so you often need to look at the criminal documents, talk to the criminal attorney. What exactly were they convicted of? If somebody pled to reckless conduct, for example, but they were charged with assault on a police officer, you could still probably sue for malicious prosecution because they did not plead to attacking a police officer. They pled to something different. So you have to look at the specifics of what they were convicted of and then what you want to sue for. Heck does not bar excessive force cases. So if there is an incident that occurs and someone does plead to a crime, you likely cannot sue for false arrest, but you can still sue for excessive force. So that's an important thing to remember. The next most common defense is qualified immunity. So this means that an officer can be liable only if they violate rights that are clearly established in light of existing case law. This is a huge bar to 1983 litigation. And so I was surprised to find, where does this come from? And it was invented by the Supreme Court in 1967 in Pearson v. Ray. A recent case that discussed it was Ashcroft v. Al-Kid, in which Scalia, a supposed originalist, wrote, existing precedent must have placed the statutory or constitutional question beyond debate. Qualified immunity can be a big problem. And with the current makeup of the Supreme Court, I think it's an incredibly big roadblock for plaintiffs. I included one such case in your materials for you to read. Qualified immunity is something that you have to think about from the start because it's going to be raised. So you need to be ready for it. Okay. So that's a federal case, the overview of the claims in a federal case. So as I mentioned before, you always want to think about what state law torts you might have as well. And so some common examples are false imprisonment, malicious prosecution, battery, false arrest, conversion, stealing, trespass, invasion of privacy by intrusion upon seclusion. You want to see, and you want to allege any tort, that you can. Most of these are self-explanatory. The one I included at the end comes from a case that we had where a person, so this is invasion of privacy by intrusion upon seclusion. We had a female who was arrested, and when she was in police custody, she showed the police officers her phone, actually gave them her phone. It was to disprove something that was being claimed about her, I think, in terms of maybe threats she had made against a person, a number of calls she had made, something like that. And the police officer, when he had her phone out of her sight, he opened up her photos, found nude photos, and forwarded them to himself, to his personal cell phone, which she only found out a couple days later when she was looking at her sent messages. We pled that tort, and the reason we pled that tort is because there was some bad case law about qualified immunity. Judge Holderman, who at the time was the chief judge of the Northern District of Illinois, found the police officer in that situation was entitled to qualified immunity because there's no clear case law saying that you can't take an arrestee's phone and forward things from it to yourself. Which I think was a very bizarre decision, but one we weren't surprised by, which is why we pled this state law tort. And so now what I want to talk about are common defenses